Major breaking news out of the state of New Mexico. The National Association for Gun Rights has already commenced a major lawsuit challenging the constitutionality of the obvious unconstitutional order by the governor of New Mexico that says that you cannot carry a gun in Albuquerque, New Mexico, and surrounding areas, even if you have the right or the license to carry a concealed carry or open carry gun under the permitting scheme out there. Nevertheless, this lawsuit has been brought, and I suspect it's going to prevail, but only time will tell. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gunners, the A to Z guide about how the anti-gunners will try to take away our guns, but we're going to work hard to stop that. I lay out their strategy in this book because I've been studying them for many years. I went to law school with a lot of these people, so I know how they think, and I laid it out in First They Came for the Gun Owners. Check it out if you don't own a copy. All right, folks, the National Association for Gun Rights, a major gun rights group. You're familiar with them, and their major attorney, Barry Arrington, has brought a lawsuit alongside attorney Tim White out in Albuquerque, New Mexico, in federal court there, challenging the Michelle Lujan Grisham's order that says you cannot carry a gun, notwithstanding the existence of the Second Amendment, notwithstanding the existence of Nysurpa versus Bruin, notwithstanding the existence of having a carry permit issued by the state of New Mexico. You're not allowed to carry guns in Albuquerque and some surrounding areas as they define it under some criteria. They're trying to create a gun violence emergency. But as you know, this is blatantly unconstitutional for several reasons, one of which, of course, is you cannot engage in interest balancing in the context of applying the Second Amendment. It's all about historical analysis, which the government clearly did not do here. Now, just to jog your memory what happened here, she entered an order that says that no one is allowed to carry a gun in a particular area, which is really known as the affected area of Albuquerque, because she says there's too much violence there, too many criminals there, too much gun violence, which, as you know, does not exist. There is no such thing as gun violence. That's a propaganda term by the left. She says that there are some exceptions, of course, and here's one of the interesting exceptions that I think could be exploited. She says that actually the guns, one of the exceptions to her order is guns that are on private property, owned or immediately controlled by the person. Now, you could be a little slick here, and I'm not recommending you do this, but you could be a little slick because, technically speaking, I suppose private property owned or immediately controlled by the person could be arguably your body. Again, I'm not necessarily saying you should go out there and try this and get arrested. I would not recommend this, but it's kind of interesting how even the way she's crafted this order of exceptions could be subject to multiple interpretations. The other thing, of course, she's trying to say is you cannot have the gun in anywhere in public property, and you are permitted to have it on private property, provided that that private property is not open to the public and you have the consent of the owner of that property. So conceptually, what I think she's trying to talk about is you want to bring it to your friend's home. You can have the gun in your friend's home, provided that your friend gives you consent, because that's private property. I think that's what she's trying to get at here. Nevertheless, all of this is unconstitutional under the Supreme Court precedent, Nysurpa versus Bruin, and the lawsuit brought by the National Association of Gun Rights is a short and sweet complaint, about 8 or 9 pages long, but it is crystal clear that they have the winning argument. They remind the court specifically that the text of the Second Amendment is paramount. The text of the Second Amendment says, of course, the right to keep and bear arms shall not be infringed. We know from the Supreme Court's decision in Heller and Bruin and McDonald that the right to keep means the right to possess, and the right to bear means the right to carry guns in public for all lawful purposes, including but not limited to self-defense. The National Association of Gun Rights made that point quite powerfully in their paper submitted to the federal court there in New Mexico, seeking a TRO and a preliminary injunction. I'm guessing they will not get a judge until Monday morning, and we'll see what happens on Monday morning when a court and a judge is assigned. Beyond that, what's also interesting is they have sued on behalf of the organization themselves, as well as the plaintiff, Foster Allen Haynes, as the individual plaintiff. He says he lives in Albuquerque. What I might also do if I was the plaintiffs in this case is I might try to get some additional plaintiffs to make sure you do not have a standing issue, because, as you know, federal courts under Article 3 of the Constitution cannot hear cases unless there's an active case or controversy. One of the things that judges look to is whether or not the plaintiffs have standing, which means that you're directly impacted by this order. Having more than one plaintiff is always a good idea. And I think that would not be a bad idea here to add additional plaintiffs in, even if those people do not live in Albuquerque. Certainly if they travel to Albuquerque or through Albuquerque, again, that would give them standing. I might even have a press conference next week in Albuquerque with a bunch of the plaintiffs to show that they do indeed go to Albuquerque because, among other things, they intend to go to the state capitol to protest, to talk to the governor, and so on, to show that they do indeed go to Albuquerque. I think that would help demonstrate standing in this case. Now, as you know, once the text of the Second Amendment is implicated by a gun control law, this order obviously is a gun control law because it is precluding someone from having the right to carry guns in public for self-defense. That implicates the text of the Second Amendment, i.e. the right to bear arms. So now once the text is implicated, the burden shifts to the government to come out and justify their law. And the way they justify their order or gun control law is not by arguing it's a good idea or good policy or saves lives. That is not an acceptable argument involving the Constitution dealing with the Second Amendment. They have to come forth with demonstrating that there are historical analog laws at the time of the founding that are consistent with or show a long-standing tradition of this kind of gun control law. The example I always like to give is you go back to the time of the founding, you could not use guns to commit rape or robbery or murder, and therefore a modern-day gun control law that prevents you from committing rape, robbery, or murder is also would be allowable under the Second Amendment. That would not violate the Second Amendment because even at the time of the founding, everyone understood that the right to keep and bear arms did not allow you to use guns to commit crimes, and that, of course, held true all the way through today. That is the sort of historical tradition the Supreme Court is looking for, and not the sort of thing that's being made up by the 21st century anti-gun community in their academic halls. So now we know this gun control law implicates the text of the Second Amendment. The burden shifts to the government. They have to show some historical gun control law at the time of the founding that's analogous to this. They're not going to be able to do this because, as you know, when the founding fathers saw there's a particular area that was dangerous, they often actually required people to bring guns. This was the case with certain churches at the time of the founding where there was worry about on Sundays the Native American tribes, the Indian tribes would know that the colonists were there and were vulnerable. So in those cases, there were states that would require Americans to bring guns to the churches. In other words, rather than make those churches tomahawk-free zones, knife-free zones, or gun-free zones, they actually armed the parishioners. And again, that is the sort of tradition we're talking about in the United States. It is not the sort of tradition that Governor Grisham is trying to create today. That will not work under the Second Amendment and Supreme Court precedent. The other observation I want to make, and this is very important, is that the New Mexico Constitution actually guarantees the right to keep and bear arms. This is different than some states like the state of New York, for example. Let me give you the language. The New Mexico Constitution says, in effect, no law shall abridge the right of a citizen to keep and bear arms for security and defense, for lawful hunting, recreational use, and for other lawful purposes, but nothing herein shall be held to permit the carrying of concealed weapons. Now, this is key. I want to clear up some confusion that sometimes comes out on the internet. You have a right to carry a gun that is understood all the way back to the founding, but there is an understanding in many parts of the country that although you have to be allowed to carry a firearm, there is regulation allowed as to whether or not you're allowed to carry the gun open or concealed. So there are states that say you can open, and this is back in the old days, you could open carry, always open carry, but concealed carry is a more modern thing because at the time of the founding, people generally open carried and did not conceal carry. So as long as they allow you to carry guns, the general rule is the right to keep and bear arms is satisfied. Here, the New Mexico Constitution contemplates open carry, but the governor here is banning open carry and concealed carry, so that clearly violates this constitutional amendment in the state of New Mexico, in addition to the federal constitution of the Second Amendment. Moreover, I want to bring to everyone's attention the city of Las Vegas versus Moberg. This is not about the city of Nevada, not about the city of Las Vegas in Nevada. This is the city of Las Vegas versus Moberg in New Mexico in the year of our Lord, 1971, the Court of Appeals. Specifically, this is what the court said. This is important for you out there in New Mexico to pay attention, who's paying attention to this. This is what the court said, that you cannot violate the right to bear arms in New Mexico under the New Mexico Constitution. This is what that New Mexico state court said. Remember, this is not a federal court I'm about to read from you. This is not the Second Amendment. This is a state court. It says, quote, "Such gun control ordinances do not deprive citizens of the right to bear arms. Their effect is only to regulate the right as applied to arms other than those concealed. The ordinance under consideration purports to completely prohibit the right to bear arms." Did you hear what I just said? The ordinance that they were talking about in 1971 purported to completely prohibit the right to bear arms. And what did the court in 1971 say in New Mexico? It said, quote, "It is our opinion that an ordinance may not deny the people the constitutionally guaranteed right to bear arms, and to that extent the ordinance, the gun control ordinance of 1971 they were talking about under consideration is void." period, close quote. Did you hear what I just said? The City of Las Vegas versus Mowbray case, 485 P. 2nd 737, which I'll put a link to down below, New Mexico Court of Appeals said that under the New Mexico Constitution, you have a right to carry guns, and anything that bans the outright carrying of guns in the state of New Mexico is void under the state constitution. This is an independent reason beyond the federal constitution as to why this is unconstitutional. Now, I noticed the National Association for Gun Rights did not make that argument here. They may not need to make that argument, but it's something to keep in mind. And the only other thing I want to mention here is people keep asking me on Twitter, at 4Boxes Diner, by the way. They keep asking me, can the government be sued personally? This is a tricky little question. There's a doctrine under the 11th Amendment, which generally speaking, you can't sue state actors for money damages in federal court. That does not apply to attorney's fees, which the National Association for Gun Rights and Barry Arrington have asked for here under 42 U.S.C. 1988. You can get attorney's fees, but you generally cannot sue for money damages state actors such as the governor. Now, there may be some exceptions here under what's known as the Bivens doctrine, where someone who's a state actor actively, knowingly violates the constitutional rights of someone else. That is a possible way to get personal financial damages, financial harm against a state actor. It's very narrowly drawn. It's usually applied just to police officers in the context of those who violate the Fourth Amendment's right against searches and seizures, or unreasonable searches and seizures, or warrantless searches and seizures. Nevertheless, that is out there. That's called the Bivens doctrine. If anyone wants to sue the governor for damages, you're going to want to take a look at both the 11th Amendment jurisprudence by the Supreme Court, the sovereign immunity rules in New Mexico, and the Bivens doctrine as well by the Supreme Court, and whether or not you can extend that to the governor. It's a tricky little issue, but it's something to keep in mind because this is a gross violation of the Constitution as I see it. And again, well, that's where we are. We hope the National Association for Gun Rights and Barry Arrington and Tim White go out there and kick some butt along with the plaintiff, Foster Allen Haynes. And we'll be tracking this case along with the other cases if there are any sued out there challenging this ridiculous New Mexico order. And again, thanks for following us here at the 4Boxes Diner this weekend. And if you haven't subscribed to the 4Boxes Diner, please do so. Don't forget to follow me on Twitter or X at 4Boxes Diner. And we'll see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.